AfriForum and Solidarity wrote to the Minister of Basic Education, Siviwe, Gwarube, and President Cyril Ramaphosa separately, calling for urgent engagements on their dissatisfactions with regards to parts of the BELA Act. We will now speak to Werner, who is the head of operations at Solidarity, on the details of their requests and concern. Werner Human joins us now. Werner, good evening. Thank you so much for your time. Really do appreciate it. In the letters that you wrote to the President and the Minister of Basic Education, you asked for engagements. When the President had initially signed the BELA Act with the suspension of clauses 4 and 5, it was very specifically for a 3-month engagement period. Was that not sufficient?
Good evening, and thank you for the invitation this evening. That was a sufficient time, and in that time, we were able to produce solutions. We got an agreement in NETLAC. We've got the list of recommendations by the minister. But what has transpired, and I think this is what a worrying fact is that it seems like the law and the reason did not really surface in his considerations. What we have seen is that on the political level, there's been many pressures on him to continue with this act, but political considerations are not always the considerations that are sound in law and reason. So the fact that he has signed the proclamation notice necessitated us to write this letter of demand. So the time was sufficient, and we welcomed that. And that's why we still say we want a solution outside of the courts. And that's why our letters of demand has the legal grounds, there's a legal route, but we still say that if we can salvage this, there's still time, and we are able and willing to discuss with him and any other party a road forward.
Yeah, but the legal position you're talking about has not yet been determined. There's no declaration on the unconstitutionality or inappropriateness from a legal standpoint, the clauses 4 and 5 of the BELA Act. That is yet to be determined by a court of law if you do choose to challenge, to go forward to challenge the legality and constitutionality of clauses 4 and 5. But to ask you the question, what were the solutions in the 3-month period that you had brought forward in the alternative to the engagements?
To place it in very simple terms, what we stated was, firstly, on Section 4 and Section 5 of BELA, we say that we believe it offends the Constitution, it offends the jurisprudence that has been built up for 30 years, and it offends the Schools Act as well. But we know that at this point, to say that we must at this stage go for a legislative amendment is a long process now. So our solution is firstly to defer the working of Sections 4 and 5 once again. And secondly, what has been common cause between the parties is that 3 things must happen. The first thing is that there must be norms and standards developed for language policy in the country. The norms and standards are more than 27 years old. We are a language diverse country. Our movement places a high premium on mother tongue education. We think that quality education and mother tongue education go hand in hand, but we have the majority of our learners in this country, almost 90%, have to go through to grade 12 with English language, and that ultimately places them in a worse position. Secondly, we say that there must be norms and standards developed for capacity determination. This has been mentioned by the courts in this past 10 years, that these documents have not been developed, and that is also in the Act mentioned. And thirdly, there are admission policies that are still in draft form, which will also settle the issue or address the issue of feeder zones, school vicinities, and that's also outdated. And we say you need to have those documents ready before you can commence and go ahead with Section 4 and 5.
What you're calling for, Werner, seems to me to already be happening. The Minister of Basic Education had announced a timeline for the development of draft norms and standards, both for Clause 4 and 5, and of course, including that a consideration, feasibility and capacity building. So what you're calling for is already part of the ongoing process. Should you rather not then participate in the drafting process? The draft will become available in the middle of 2025, rather than head to court as a first instance.
Yes, no, that's a good point that you're making, and we welcome that development. That's what we've been asking for, and we will partake in any event, regardless of what transpires with our court action or our route. We will partake in that. But what we've seen, and again, this is unfortunately, I must say, on the political level, our issue was, and that was also agreed by the parties, including the presidency, that for these documents to be properly developed and incorporated, Section 4 and 5, the working of them, cannot be immediate. And that
but Werner, it has not yet been operationalized, given that the regulations for it still has to be drafted. So as schools are operating right now, they're not operating under the regulatory implication, or at least under the statutory implication of Section 4 and 5. That is yet to happen at a much later stage.
No, not correct. And the effect of the proclamation of the President on 26 December makes that official, and it makes it the Act. And that was also proclaimed by certain political parties and certain figures to say that Section 4 and 5 has been proclaimed. There's a difference between Section 4 and 5 being an Act and Section 4 and 5 being proclaimed. If it's proclaimed, it means it is in operation. It doesn't sit still. And therefore, it requires of us to say that's not what we've said. And what the President has done, he said these documents that we've negotiated and pressed, that must be developed, and that's correct. But on his side, he also had pressures to proclaim, and we say that was not the correct step.
Yeah, I mean, you and I both know that an act finds no life if there's no regulatory framework for that act to breathe through. And of course, you can't write regulations for an act that doesn't exist. It first has to be an act of law before you can draft the regulations for it. Just lastly, has the presidency and or the minister responded to your letters of demand, and have they acceded to engage you on this?
Yes, so we afforded the President and the Minister 10 days to respond to our letter. We've requested a meeting or reasons for the decision, and on both the sides, we received an acknowledgement of receipt, and that is positive because it means that we will have some sort of engagement.
Yeah. Werner Human, thank you so much for your time this evening. Really do appreciate. Werner Human is the head of operations at Solidarity.